my good friends, I had a thought-provoking experience today, and it just made me wonder, and I got enlightened about something that we all take for granted, and that's your ex-husband or wife that you call ex without formalizing your divorce with that person can access your estate without your consent at the detriment of any member of your family. Yes. Are you surprised? Yes. I saw it at the probate, and it made me wonder, a lot of things that we take for granted. Now, I just I want to advise you to watch this video to the end, though, because this information in this video may not be beneficial to you now, may be beneficial to you in future. It may be beneficial to someone that is close to you, someone that you know. I'd like you to watch this video to the end, because the main gist is at the end of this video. Don't forget to share it to everyone. And please, if you like the information in this video, watch it. If you like it, please subscribe to this channel and give us a thumbs up. Incident I met today also at the probate registry, and the story is that the spouse, these two people, they had issues and separated. They've been living apart for quite a while, and they've been referring to themselves as exes. My ex, this one will say my ex-wife, this one will say my ex-husband, and that is where it ended. They married under the act, that's they did the normal registry marriage, but they did not take steps to legalize their divorce. They just divorced by word of mouth and by living apart. They didn't take steps to legalize their divorce. Okay, now one of the spouse died, got ill and died, and then suddenly the other spouse was seen at the probate registry trying to apply for letters of administration to go get the benefits from the deceased spouse workplace. And I now saw the sibling of the deceased, crying and throwing tantrums. Was like, you were not there for the deceased when the deceased was alive. You did this and did that and did this. In fact, you people were not married. And I can remember that the probate officer who was actually processing the document asked if they were divorced, where is the court order? There's no court order. They did not formalize their divorce. That's what I'm saying. Now, I want you to know that that's your ex. That's your ex, whether husband or wife, that you did not formalize or formally make the person your ex according to the requirements of the law, can, when you die intestate, apply for your letters of administration and apply for letters of administration to access both your money at the bank, maybe at your workplace, to access your benefits, to access your estate. Yes. And with the evidence of that, your marriage certificate, without the evidence of a court order finalizing your divorce, that's your surviving spouse that you failed to formally legalize your divorce with, would take your benefits at the expense of your family members or any other person, because the administration of estate laws place a surviving spouse who dies intestate above every other family member. That's what the law says. The spouse takes number one precedence over any other family member that may come up. So in case you don't want that your surviving spouse to access your estate, is either you prepare a will where you can now clearly state who owns what, who you wish to give out your estate to, or you apply in court for divorce, dissolution of marriage, where you can formally legalize that person being your ex, because by just calling that person your ex, that marriage is not dissolved. Yes, if there's no court order to support your claim that the person is your ex, that marriage is still valid and subsisting. Now, I want to also point to the fact that if the court order you have is just the first court order, the order nisi, the one the court gives, maybe you applied for application for dissolution of marriage, the court orders the first order that lasts for 3 months, order nisi. It is after the order nisi that you go back to court and get an order absolute. The reason why the court does that is because of the peculiarity of petitions for dissolution of marriage and the unique nature of marriage contracts, because they believe that parties may reconcile within the period of 3 months. They want to give them a window to see if they can reconcile. So they give order nisi. Order nisi is a temporary order. And when you have order nisi, that marriage is still subsisting. It becomes totally dissolved when there is an order absolute, which is after 3 months of the existence of the order nisi. If you have any questions, please, you can drop it in the comment section. If you fail to watch this video to this point, then you would have missed a lot. I hope you found this video helpful. Please, if you found this video helpful, kindly click the subscribe button and give us a thumbs up. Share this video to everybody, not just people you suspect that are having marriage. Share it to everybody, please. Thank you very much for having me, and enjoy the rest of your day.